Hello, people of YouTube. My name is Steve Gray. This is Gray's Guitars. Thank you for watching. Has Dean just won against Gibson? Unpacking the latest development in their legal battle. So you might have heard some of this already from a couple other YouTubers or just other people in general, other articles. But I just wanted to let it sit for a little while to see what was going on, making sure we had all the facts. Because, sometimes a lot of this stuff gets thrown out there. It's not actually factual or something is not the case. And then it's a whole other different situation. So, is this a clear victory for Dean? Could it actually end up helping Gibson? What's next in the lengthy trademark? So, if you are unfamiliar with it, Gibson sued Dean for trademark infringement on the, I believe it was like a hummingbird style design. They called it something else. There was the Z-type guitar and the V-type guitar, and initially they won. Dean had to stop making the shapes. Other companies continued to make the shapes, even I guess they're slightly different or something. That was the whole thing. And everybody was like, okay, way to bully them, when it's definitely not the same guitar. A lot of people can read Dean on the headstock versus Gibson. Not that hard to figure out. So, over the last 24 hours, probably like a week ago, and now in this case, Internet has been abuzz with the latest development in the lawsuit between Gibson and Dean. Both companies have stated their confidence that they will prevail in the end, while commentators are summing up things as a huge victory for Dean. Some commentators are also somewhat preempting a final judgment at the time of writing. Philip Nate's video on the topic: Gibson loses lawsuit to Dean. Will we have to pay the bill? But has Gibson actually lost anything yet? No. Ultimately, neither one of these companies, well, I mean, they've in terms of lawyer fees, yes. And then, Dean obviously losing the right to make those shapes. So it's been over 2 years since a jury first found Dean's parent company, Armadillo, and investment partner Concordia had infringed on Gibson guitar body designs. Following this, the Texas District Court that oversaw the case ordered Dean to stop selling a number of its shapes, including the V and Z guitar. Since then, Dean has been going through the appeal process, aiming to get the Fifth Circuit Court of Appeals to reopen the case. What the court said yesterday, Dean was successful in the regard that the case remained to the original court for a new trial. And before we unpack the three-judge panel's reasons for the decision of the statement from both companies that followed, it's important to clarify what appeals court has actually said. All that has technically been ordered for now is going back and do it again. So as of this moment, Dean can make those guitar shapes, currently. So why are people framing this as such a win for Dean? Well, the opinion document accompanying the judgment shed some light into why retrial is needed in the judges. Viewed the district court was wrong to disallow evidence before 1992. This significant as one of Dean's major arguments against Gibson was that the body shapes are generic, i.e. so common in their usage they are legally unprotected. However, as the court recording reveals, Dean's attorney, Ron Benstock, has argued that 5-year window did not allow for Dean to property, I think it's supposed to be properly demonstrate. I think there's a typo there. That's fine. Properly demonstrate its genericism argument to the jury. There are swatches of adverts that could demonstrate that other brands were selling visually similar guitars to Gibson's design well before Dean existed and well before Dean brought this suit. The opinion essentially agrees with Ron, stating that the district court was wrong to not allow this pre-1992 evidence in the original trial, as it was potentially relevant to Dean's central argument, and that the jury didn't see it and didn't get to see the full content in which the suit was taking place. It's put like this in the document. The jury in this case was not presented with the complete picture of what happened prior to the alleged period of infringement of the Gibson trademark. Thus, it's apparent that the wholesale exclusion of the pre-92 third-party evidence affected Armadillo's substantial rights. So yeah, I mean, you can talk about the lawsuit era, with like Ibanez basically making a one-for-one Gibson, except it didn't say Gibson on the headstock. So there has definitely been some copies well before Dean, and there's still currently copies. I mean, a lot of what LTD ESP does are essentially their own takes on those designs. Yes, they are slightly different, but I would argue they were a copy. Same with Schecter. same with Harley Benton, same with Firefly, same with like all these other third-party companies. Peavey, right there, everybody copies a Strat too and a Telecaster. New judgment also specifically states the judgment of the district court is reversed. The word reversed is going by the common usage. Pretty loaded here. However, a reversal legally doesn't mean a new judgment in Dean's favor. It just means that we're back to square one. Given those claims that Gibson has lost a lawsuit flying about, it's important to clarify the judgment has not been totally overturned in Dean's favor. It's less than Dean has now won instead of not lost. So yeah, it's still kind of like an ongoing thing, and Gibson's going to have to refile, get a new court case, and we'll see what they do ultimately. So what have Gibson and Dean said? So Gibson and Dean's statement regarding the decision read very differently, as you might expect. Let's start with Dean. It frames his decision as a major victory, which is understandable. Dean has opposed Gibson's initial motivation to exclude the evidence, and as the opinion notes, Dean's argument that was hurt by the lack of evidence, a new trial, the wider scope of evidence could shake out very differently. But it's important not to jump the gun here. Dean's statement, Pamela Rubinson calls the decision a corporate complete vindication. So we have fought this battle and won, but it's just one battle. The full legal fight has now just gotten a lot bigger, and Dean's overall success is not for a foregone conclusion, even if the new evidence could have a large impact. There is also the possibility that Dean, the far smaller of the two companies, is already mirrored in other issues, could be hurt a lot more by a loss later down the road with ramping legal costs and a second chance for Gibson to file for damages. Gibson's statement in comparison to Dean is fairly curt. Emotive quotes about battles are notably absent. Instead, it only hints at what the decision actually means and underplays the change in the playing field for the retrieval. States simply that the Court of Appeals found the district court allegedly abused its discretion in excluding certain evidence. However, certain evidence in this case encompasses decades of guitar advertisements released before '92. It's quite a lot more evidence Dean now has at its disposal to make its argument. Gibson is also clear it is not particularly happy about the possibility of a retrial, saying that it will be requesting all the applicant judges reconsider the panel decision, as it's confident the Texas judge and jury got it right the first time. The statement also relies on the brand's heritage to assert its confidence in a second victory. Gibson, like other iconic American brands, have invested in meaningful research, development, and innovation for over 130 years. Is confident that the retrial, the jury will again find in favor of them, blah, blah, blah. So what is next? Unless Gibson is successful in getting the Fifth Circuit judges to reconsider, the case will return to trial. From there, it's obviously hard to predict what happens, but it's safe to say that Dean will rely more heavily on his genericism argument, now with the benefit of 50 years of evidence to back it up. For Gibson, the challenge will be countering this new evidence and arguing that the body shapes are not generic. If Dean once again loses the wider fight, it could possibly spell the end or at least temporary disaster for the troubled company, depending on the judgment and any damages it must pay. Yeah, that was when I think it was like the son was the CEO or something, and then the mother basically kicked him from the board and took it over because he was not applying or not doing what the court ordered, and essentially getting them in worse trouble than they were in the first place. So I know that was a whole thing with Dean a while back too. On the other hand, if it's successful, the implications are much more dramatic. If Gibson's main body shapes are ruled generic, then it opens up the door to other makers, not just Dean, to use them. Say from litigation, we could see a whole new era of Gibson-style guitars, no longer legally called copies. They're just guitars. Dean's full counter, they're still going to be called copies. Regardless, Dean's full counter argument also wants to encompass the headstock. Could Gibson open book design become something anyone can use? See, it's interesting with the whole open book headstock thing, because in Japan, you can get a Les Paul that's not a Les Paul. You can get a Les Paul shaped guitar with a Gibson-shaped headstock that has like Bernie on it, or Orville, or whatever other brands, because they lost that suit in Japan, which is why you see a lot of those open book headstock Japanese guitars. Because ultimately, yes, it is the same shape, but it does not say Gibson on the headstock. It's not like a Chipson where they actually say Gibson on the headstock. Given the last case took 3 years to resolve, we're unlikely to see such seismic shifts anytime soon. Of course, we'll be keenly covering the news as it afloats, so stay tuned. Yeah, so this is just going to be one of those things where this is just another video in the cycle. When we get more news, even if it's a couple of years down the road, providing I'm still doing YouTube videos, I will make an update at that point in time, because you never know what the future brings. Let's be honest. I think they're going to win the body thing. I'll be honest with you, being that so many other companies use those body shapes. Ibanez, Jackson, BC Rich, ESP, Dean themselves, PV. I'm trying to think of some other companies here off the top of my head. Epiphone wouldn't count because that's owned by Gibson. Harley Benton, Firefly, Agile, just a whole bunch of guitar companies that have taken the body shape and either slightly modified it, basically made a one-for-one of that body shape, and then just have their own headstock. I do not think they are going to win the headstock argument, being that that has been in law for an extremely long time. Gibson does own that headstock shape. But I think the body shape, I don't think they're going to win that, and then other companies might do a one-for-one body shape, but as I said, if you look at all these other guitar companies, they're basically doing the same thing. The majority of guitar companies are copying / slightly modifying, doing their take on the Gibson shapes and the Fender shapes. Stratocaster, most copied guitar ever. Telecaster, Les Paul, Flying V, SG. What the heck else am I missing in there? Explorer. There we go. Telecaster, Firebird, Thunderbird bass, P bass, Jazz bass, all these shapes, Mustang. All these shapes are constantly being copied and slightly modified in the tiniest ways, or a one-for-one, and then the headstock is different and has a different name on it. Ultimately, I think that if it has a different name on it and it's not pretending to be that thing, then it doesn't matter. So I would have absolutely no problem if Ibanez re-released their 70-era Les Pauls with an open book headstock and it said Ibanez on it. Because if you're looking for a Gibson Les Paul, you can clearly tell by looking at the guitar on the headstock that it does not say Gibson Les Paul. It says Ibanez AXQU Elemento P123. You know, they're friggin' crazy names. So that's where I'm at with it. I think as long as it's not pretending to be something else, it's perfectly fine. I think 9 out of 10, the whole headstock thing isn't going to go anywhere, but probably is going to go to retrial, 9 out of 10. And the jury may say this time, well, you never know what the jury's going to say, but I think they're going to say this time that the body shapes are generic, the headstocks are not, and then hopefully that will be the end of it. But not everything is so black and white with these. So that's where I'm going to end it. Thank you for watching. Hit that subscribe button, turn on that notification bell, like, share, comment, all that fun stuff. And as always, have a good one.